All right. It's ahead of my notes. Today we're starting chapter 5, and this is going to center around civil rights. So we talked last time about how civil rights and civil liberties, we all kind of use the term interchangeably, but there's a little bit of a difference there. The civil liberties are the things the government can't do. They're prohibitions against things that we decide are kind of not American. But civil liberties are going to be, I'm sorry, those are civil rights are going to be those things that say that we're going to treat everybody the same regardless of some other characteristic. Our learning objective today is to continue being able to distinguish between civil liberties and civil rights, identify the constitutional foundation for civil rights, and we're going to, spoiler alert, it's the Equal Protection Clause, apply an equal protection checklist against those things. And then finally, we want to use the 3 levels of scrutiny correctly. What's the trigger? What's the government burden? And does it fit? So race and modern civil rights enforcement. Discrimination on the basis of race ended, theoretically, when we said we're not going to have slavery anymore. Did that work out? No. Absolutely not. Because we went from, hey, we're going to have slavery to, all right, we're going to get rid of slavery. But then all these things kind of emerged to take the place of slavery. We want still to have an economic lower class that we can pay nothing or very little to, right? At least that's the thinking of the country at the time. So they have terrible things like Jim Crow laws, and they create things like sharecropping to kind of, yeah, we aren't going to keep you as a slave anymore, but we're going to make it so difficult that it has the same effect. So we have the 13th Amendment. It says no slavery, and that doesn't really do what we want it to do. So we move on from there, and we have the 14th Amendment that's going to change a lot more. There are some landmark shifts going on at the time. This isn't just, so if you're listening at home and in the video it doesn't quite, my sarcasm doesn't quite come across, obviously this is a difficult topic, and I'm making light of it only because it's kind of asinine to me that it took so many different things to make this right. And so I do want to spend just another minute on that. So we've got the 13th Amendment, which abolishes slavery. The 14th Amendment is citizen rights, equal protection, apportionment, and the Civil War debt, how we're going to handle all of that. The 15th Amendment is the right to vote, can't be denied by race. And each of these happens at a different time. Like, not one of them happens at the same time. It's this progression of civil rights that kind of takes a little bit of time to make happen. And one second while I pull up the actual dates here. Because I thought I had those in my notes, but then as I'm going through it, I realize I don't. So the 13th Amendment is in 1865. That's where we say no more slavery. It abolishes slavery. Awesome. But then just a couple years later in 1868, we see all these different things like, okay, yeah, fine, there's no more slavery, but you're not a U.S. citizen, or you're not entitled, because you're not a U.S. citizen, you're not entitled to the protections of the Constitution. So in 1868, we have the 14th Amendment that has citizenship basically based on where you're born, equal protection, and things like that. I'll read through that in a minute. And then in 1870, we finally have the voting rights for all races. So it's only a short time, relatively speaking, considering the length of our country and everything like that. But it took a full 5 years to kind of figure out, here's how we're going to make this happen. So when we talk about the Equal Protection Clause, and That is essentially what Chapter 5 is about. It's important to know where that comes from. As we said, it is in the 14th Amendment, but I want to read that chunk of it to you, because the 14th Amendment is one of the biggest chunks of the Constitution. We've got Section 1 that talks all about naturalization. That's who is a citizen of the United States. Section 2 is how basically representation is apportioned among the several states. We had the 3/5 compromise. That's gone. It's now 1-for-1. Because if we're saying anybody born here is a citizen, well, we've got to treat all citizens the same. But Section 3 talks about Section 3 is about Civil War reparations, kind of. 4 is about the civil debt. And then I skipped the second half of Section 2. So I'm just going to read Section 2 in its entirety. Representation shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote of any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial offices of a state, or the members of the legislative thereof, is denied to any of the male inhabitants of such state being 21 years of age and citizens of the United States, or in any way abridged, except for participation in rebellion or other crime, the basis of representation herein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age of such state. So I want to bring that up because there's always a debate about, well, I thought you just said that they can't say somebody can't vote. Well, they can if it's a crime, if there is treason, something like that. That's why a lot of times if you're convicted of a felony, you're not allowed to vote. And then the Equal Protection Clause comes right after the naturalization stuff in Section 1. So all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So that's naturalization. That means you're a citizen. But here's the point I want to talk about. And here's, when we get to this right now, I want you to pay attention to the difference in wording here, because this has all the bearing about kind of what is going on in our country today. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So the first half of this starts out the same. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens. That's the Privileges and Immunities Clause. That means that if the laws about marriage are different in Illinois versus Missouri, if you get married in Illinois, Missouri has to honor that marriage. But here's the wording that's different. Nor shall any state deprive any person. It doesn't say citizen, it says person, of life, liberty, or property without due process of law. And here's why this is so important. We talk about, we've talked about it in here, what's going on with immigration enforcement and stuff like that. When we talk about due process, that's not a right that is given to citizens. And that's an argument that's been made by lots of people. They say that it is, we don't really have to worry about that because they're not citizens. The Constitution doesn't say citizens here, it says persons. So if you are a human being in the United States, then under the 14th Amendment, you are entitled to due process. Does that make sense to everybody? It's a really big idea, but I really want to hammer that because when we go back to the original wording, it kind of changes the meaning that we're going to be looking at here. All right, that was a big rabbit hole, but let's skip ahead and start talking about other stuff too. We talked about this last time. In practice, civil rights are going to be enforced through the courts and laws passed by Congress, but usually there's going to have to be a challenge by a citizen to get there. Civil right arguments are often fought in court, but many civil rights gains come through legislative action as well. So equal protection claims, when we're thinking about these, when we think about is something going to be protected under the 14th Amendment, I want you to be thinking about it through this lens. And there are going to be 6 steps to this framework. The first, is this state action? Is the government doing something to clarify or enforce the law? Second, what's the classification of that? What category is the government using? Are we talking about race, sex, age, etc.? This is going to bring us to number 3. What level of scrutiny are we going to apply? Which test applies based on the classification? 4, what's the government interest? What is the government trying to accomplish here? 5, we're going to see if it fits. How tight is the connection between the rule and the goal? And then 6, predict the outcome. We talked about that framework a little bit last time. It's very much the same as what we're going to apply when we're talking about civil liberties. Civil rights make it a little bit different because we're talking about just a little bit different classification. So here's a guided walkthrough of this. If a city gives a hiring preference to veterans for city jobs, is this something that's going to be okay? So if we look at that 6-step thing first, is this state action? Yes. When we talk about state action, that is going to be the action of the government, typically. It doesn't have to be the state of Missouri doing the action. It can be a local government. What's the classification here? Veterans. So have you served in the military is going to be the classification we're looking at. Then we get to what's the likely scrutiny? It's most likely going to be rational basis. And the reason for that is veterans are not a protected class. There are lots of laws on the books that will give different treatment to veterans or will give them some protections. But historically, people haven't been discriminated against because they've served in the military. People have been discriminated against because of the color of their skin, or whether or not they're male or female, or whether or not they're disabled. And because of that, we're applying the rational basis test. So does it fit? Well, I'm sorry. What's the government trying to do? Obviously, they're trying to provide a benefit for people who've given service to the country. Does having a preference to hire veterans achieve that goal? What do you guys think? Yes or no?
Probably.
Yeah, probably.
I mean, if it's like Vietnam veterans don't get hired.
Yeah. And again, because it's rational basis, all we have to do is pretty much say, is this rationally related to what you're trying to achieve? And if it is, then what's the prediction? Is this going to be okay, yes or no? Shout out an answer. You give me a thumbs up, so I'll take that.
Preference is not mandatory.
Exactly. And I will tell you, so yeah, this would absolutely be okay. It happens all over the government. You can, lots of times you have to, if you want to apply for a federal job, it's very competitive. But there's Schedule A hiring where if you're a veteran, if you're a person with a disability, you can bypass that competitive hiring process. All right. So we talked about this a little bit last time, but I'm going to go into a little bit more detail again here. There are 3 types of scrutiny. So when I'm talking about scrutiny, we're always kind of at that judicial level. All of these are going to be judge-created doctrines. We kind of had the Supreme Court say, all right, so we've got this equal protection law. We have to treat everybody the same. Fantastic. How do we decide if we're treating people the same? How do we decide if, and I want to take a step back because I want to explain what's difficult about this. If we say that we want to make sure everybody gets the fair amount of ice cream, and for those of you just walking in, the little person in the corner is my son AJ. He's just watching Paw Patrol, or I don't have any idea what he's watching, something on Disney Plus. I'm going to use him as an example. Should him and I have the same amount of ice cream if we're having ice cream? What do you guys think?
It's a preference, but no.
It's a preference? You said no?
Like, just whether you want to or not. You decide.
I decide? Fair, but I'm asking you guys to decide. So pretend you're his parent and you've got a giant container of ice cream right there. How many scoops do you give each of us?
I would say 1 scoop for the child and then 3 scoops for the adult.
I like the way you think. Is that fair?
Depends on how he feels it's fair, honestly.
His opinion doesn't matter. He's a minor, right? No.
It is.
Well, so you could say that that's fair. You could say that it has to be equal. 1 scoop for him, 1 scoop for me. You could say that it has to be by weight. We're going to get exact here. He gets 100 grams of ice cream. I get 100 grams of ice cream. But there's different ways that we can look at what makes this fair. And it is the same way when courts are trying to come up with tests for things. And if you go on to study more legal stuff or go to law school, you're going to hear about all these different tests, like factor tests and example-based tests. And when we're talking about the different levels of scrutiny, these are 3 different tests that the court came up with to ask the question, is it fair? And the reason we have these is because fair means different things in different circumstances. If we are in some sort of, scenario where we're dying, we're on a life raft in the middle of the ocean, and the question is how much water does each of us get, that's much more important than how much ice cream we're going to get today. And so we're probably going to want to apportion that out differently. I'm just kidding. I would give him all the water. When we talk about these 3 tests, I want you to keep in mind that we're not going to get into the details of how they were formed. But the court basically came up with the first and third to kind of set the guardrails in either direction. With the third, with the strict scrutiny, was this needs to be so protected. We cannot let mistakes happen, like that water on the life raft thing. And so it's the hardest test to overcome. And then they had things come up that were, not things we needed to worry about. Whose book am I going to read first tonight, right? Between my kids. That's the lowest level of test, the rational basis test. And then they said, well, there are these things in the middle that they're not quite as scary as the strict scrutiny test, and they're not quite as trivial as the rational basis test. And that's where we have this intermediate scrutiny. It's going to make more sense once we go through this, but I think it's helpful to understand that these things don't emerge in a vacuum. They don't just they weren't written in law, they weren't in the amendment. The courts came up with this over time to kind of say, here's how we're going to handle these different levels of things. That said, I haven't heard many people who want to challenge this. When we have things like the right to privacy, there's lots of people who for a long time have wanted to challenge that thing that's not in the Constitution. Similarly, we have had things where people say this ought to be in the Constitution. The court just recognized something called the major question doctrine, and that is not in the Constitution, but it deals with what kind of power the legislature can give to an executive branch. And they said, well, if it's a major question, the legislature can't give their power to an executive branch. Nowhere in the Constitution, people wanted that. Now it's part of how we interpret it. And then on the flip side, we have things like, we talked about the right to privacy. We have things like the Second Amendment, where we've kind of expanded beyond the text of the Constitution, and there are people who want to protect that. They want to keep that expansion in there. There's also people on the other side who want to limit it more. So let's talk about the tests now. So the rational basis test, this is the default unless you can show something that would elevate it. The trigger is going to be most classifications like age, income, occupation, stuff like that. For example, when we talk about how people are taxed, you could say, well, it violates the Equal Protection Clause that because I make more money, I get taxed at a higher rate. Well, that's going to be rational basis. That's not going to be trigger one of the higher tests. The government must show a legitimate interest. How do we determine what a legitimate interest is? Well, we talked in the first couple of classes about the enumerated powers, the reserved powers. If the government, that's the gold standard. If the federal government tries to make a law and they have to show that there's a legitimate interest in making that law, if they can say, well, this is one of our enumerated powers, or if this is the state, they can say, well, this is one of our reserved powers. But that doesn't cover every scenario. If the state of Missouri wants to say that you have to be a certain age to get married, so we can't have 9-year-olds marrying 9-year-olds on the school playground, then that's not in the Constitution. It's not a reserved power. It now is in statute, but it's not part of the Missouri Constitution, at least not when it was written. Maybe it is now. But what we are going to say is that that's traditionally a state thing. The states have normally regulated marriage age and such. It's part of their police powers. Police powers doesn't appear in the Constitution, like we said, but it's something the states have. So, okay, that's going to be the government having a legitimate interest. It's part of the police powers. Similarly, education. Does it say in the Constitution that the state of Missouri has the right to determine what the curriculum is for my first grader? No. But that's a role traditionally served by the state, and so that's going to be something the state gets to do. Now we come to how the test gets its name. The government must show that the law is rationally related to that legitimate purpose or legitimate interest. What does rationally related mean? You have to be able to. So in law, we like thinking of things. We like creating analogies for everything, and one of the analogies is: does it pass the red face test? Does anybody know what the red face test is? It is: can you make this argument without turning red in your face? Or, to put it the other way, does making this argument embarrass you? If making the argument is embarrassing to you, then it's probably not rationally related. That's about as tricky as this gets. The court will go through a lot of different analysis, but there's not a framework here. There's not, it has to meet these tests. It's not a very stringent bar to overcome. I had a student in American government several years ago. I do not think they still attend Lincoln because it's been more than 4 years. But they argued that they didn't turn in their final paper because their computer died. And they had gone to the store where their computer was at to pick it up, and the guy wasn't there, and there was no indication of when they would go back. And I said, which computer store did you go to? And they told me. And I said, oh, that is fascinatingly interesting. Did you notice anything else interesting at this location you were at? You know, like any offices that might have been in the same building. And she's like, no. I'm like, well, what was it across the street from? And she's like, I don't know, just other buildings. I'm like, oh, that's interesting. At the time, I was running a private practice, and the technology store was on the first floor of a 2-story tall building, and my office was on the 2nd floor. And right across the street was the courthouse. And I told her this, and then I said, now, Do you think that your excuse for not turning in your final paper passes the red face test? Knowing now that I was in that building and I know that that store was open all day because I talked to that guy frequently, and right across the street is the courthouse and we talked about it frequently. And she's like, what's the red face test? And I said, yeah. So obviously, you know, gave her extra time on the paper. Please don't toy with me like that. But the fact of the matter is that if you can make an argument like that and you feel good about it, if you feel like you're not going to get in trouble, you probably have a rational basis, right? If you can't, then you probably don't. So the bottom line here is that the government usually wins because this is an insanely low bar. We're going to skip intermediate scrutiny because I want to stop. I want to show you kind of how there's the two guardrails. So we're going to skip ahead to strict scrutiny. Strict scrutiny is going to be triggered when there are suspect classes. What does a suspect class mean? That means that the classification is something that has historically been one that we discriminate against. So race, national origin, disability, things like that. Or when there are some fundamental rights concerned. So we talked last time about how if we have freedom of speech that's brought in, we might be concerned that we are automatically going to apply strict scrutiny. The government must show a compelling interest. This isn't a legitimate interest. It's not one that they have the power to do, but it's one that they have the power to do, and it's really, really important. What are some things that would be compelling interests to you guys? Oh, come on. Where do we give up civil rights and we're like totally cool giving that up?
So where or when?
Where or when? Yeah, either one. Has anybody gone to the airport recently? Did you know when you fly, they can look through your phone and things like that, and if you don't have it locked a certain way, this is actually a fun aside. If you have your phone like locked with Face ID, they can have you look at your phone to unlock it. There's my bike app if you're curious. Like it shows me the percentage charge of my bike. But if you have your phone locked in a way that you have to put your passcode in, they cannot require you to put your passcode in because that would be a violation of your First Amendment right to not speak under freedom of speech. So how do you do this? You're going to the airport, you're going to fly, you don't want them to look at your phone for some reason, any reason. Maybe you just don't like them being able to have that power like me. But you want the convenience of Face ID once you're through security. If you have an iPhone, power up or volume up, volume down, hold this until that comes up. And then you can hit cancel, and now all of a sudden it says you have to put your passcode in to unlock Face ID. That's a trick. We give up a lot of rights when we fly. Why do we give up these rights when we go through TSA?
It's convenient to travel.
It's convenient to travel.
Safety.
Safety. Yeah. Anybody ever heard of this thing called 9/11? You know, the safety at airports is really important. We want to be safe when we're flying. There's a lot of studies that say a lot of the things that we do at an airport is just to make us feel more safe, and it doesn't really add to the safety that we enjoy. That said, it's an important thing that we are willing to trade some of our freedom so that if somebody has a shoe made out of plastic explosives, that shoe doesn't make it through. And we give up a lot of freedoms. Has anybody done one of the backscatter scanners?
Seems like that where they take it over if you want it.
Where they what?
And you take the bar of the
go across your body?
Yeah, so it's called like backscatter technology, and you get in this thing and you stand there like this, and the bar goes whoosh whoosh, and that thing like basically sees you naked. Like it can strip everything off of you. They've since added some technology to make it less revealing, but it used to be a lot more invasive than it is, and we're kind of okay with that because the alternative is that we're not safe. I haven't done backscatter in a long time because if you have TSA pre-check, they usually just send you through the old school metal detector. But yeah, I mean, I'm not going to not fly because of that either. So this is something that would be a compelling interest. The government really wants to make sure that people don't crash planes into buildings or blow things up. It's a lot more than that rational basis test. People say, when you say, do you want your airport to be safe? Not just yes, but hell yes, right? So what does the government have to show? Oh, I'm sorry. So what law must be, what must the law be? So we talked about how this is when we're talking about a certain rights or certain suspect classes. We said we have to have a compelling interest. Now the law has to be narrowly tailored to achieve that goal. And we get into the concept of false positives versus false negatives. And this is an interesting thing I like talking about as it relates to criminal defense or criminal law generally. In our system, we have set it up to basically say that we would rather 10 guilty people go free than one innocent person be imprisoned. We would rather have the false negatives, that is saying that somebody is guilty, or we're going to conclude someone's innocent even though they're guilty, than have the false positives, where we have an innocent person that we say, you're guilty. With something that is enjoying the test of strict scrutiny, it's the same thing. We want to always have the scenario where we are getting the right person in trouble or we are protecting the right thing rather than having false positives slip through the crack. That I feel like that's about as clear as mud. Does anybody have any questions about that? When we talk about strict scrutiny, the government almost always loses. There are some exceptions, but typically the government is not going to survive a strict scrutiny test. So now we get to intermittent scrutiny. This is things that are going to, we call quasi-suspect class. Quasi, does anybody know what the term quasi in front of something means? Quasi means sort of, or fake, not really. If I say it's a quasi nice day, well, the sun's up, but it is, as we are recording, I got to put in my passcode because I locked the phone. As we're recording this class, it's 29 degrees outside. So if I say it's a quasi nice day, I might be talking about the sun, something like that, but it's not fully nice. It's not 65 and sunny. And it's just that with when we talk about quasi-suspect classes. These are going to be things like gender. We talked about that last time. With gender, about half the country is male, about half the country is female. There's not a minority of one versus the other, but there has been a tradition of discriminating on the basis of gender in the United States in terms of what jobs people are eligible for and things like that. So gender is pretty much the only one I think that goes in here. There could be others, but when we talk about intermittent scrutiny, we almost always are talking about sex or gender. The government here must show an important interest. It's in between compelling and, did you have a question?
Yeah, I just wanted, isn't it still true, like, women get paid a couple cents less than men in certain jobs?
Oh yeah, statistically, women get paid less than men. And we could look up those numbers, and there are lots of arguments for why that is the case. And we talked in here a couple of classes ago about the difference between equal opportunity and equal outcome. For example, one of the arguments as to why statistically women get paid less is because a lot of times women have to take a lot of time off when they have a baby because they want to, or because they have complications, or because it's the right thing to do. And if you are gone for a portion of a year, it's likely that you don't get as big of a raise as everybody around you, or you don't make as much commission, or whatever the payout schematic is. Women are typically held back if they have kids. They have the same opportunity to make money, would be the argument why that's okay, but the outcome is different. And there's a huge potential for debate about what the best outcome there is, what the most fair thing to do would be. But when you look at the salaries of men versus women across the board, absolutely women tend to make less than men. Similarly, a man who is going to take parental leave is statistically going to make less than a man who doesn't take parental leave. I'm not commenting about whether or not that's fair. I'm just trying to present both sides of it there. Does it make sense? Yeah. So we talked about the government must show that there's an important interest. The law must be substantially related. This isn't a rational basis. This isn't like saying that, hey, if we want to increase attendance at Lincoln, we're going to give out scarves. This is saying that we're going to have to do something that is substantially related to the outcome. Again, it's in between narrowly tailored and rational basis. And the bottom line is this is a toss-up. The government wins some, the government loses some. And basically with this, it falls right in the middle. Everything from important interest to substantially related. It's designed to be kind of a middle ground here. Any questions about the levels of scrutiny or when they apply? All right, let me see what all I've got left because I've got 10 minutes. Let's walk through an example here. I've got a few, and I want you guys to just yell out what test do you think it's going to be. So if a state sets a different drinking age for men and women, what level of scrutiny do you think this is going to be?
Sorry?
So it's going to be rational basis, intermediate, or strict.
Strict.
Why strict?
So I don't think there's really a biological reason why.
Lincoln University, stop AJ. Lincoln University not having like on-campus fraternity houses and stuff makes teaching this sort of thing so much more difficult. Because if you guys had fraternity and sorority houses, you would be like, that is such a good idea. Because it's not usually the sorority houses that are having the ragers. It's usually the fraternity houses. Here, this is a tricky one because my first guess would have been the same as Ural's. I would have said, oh, it's definitely strict. There's no reason to discriminate based on gender. But if we look at what the trigger is the trigger going to be age, income, occupation, or sex or gender, or race, national origin? Which trigger are we looking at here?
Gender.
Yep, and trigger is going to tell us that it is most likely going to be intermittent scrutiny, right?
Yeah.
Yep. So that's a really tricky one. 2, a city program gives preference to minority-owned contractors. What do you guys think?
Bottom line.
Yep, rational basis. Good work. 3, a state requires a license for hair braiders.
Don't you need a license to cut all hair?
Nope, to braid hair.
Oh. Let's say high scrutiny.
Why do you think high scrutiny?
Because braiding is usually tied to minority.
Yeah, I think this is one that could either be rational basis or or strict scrutiny. Because if we're saying that you need a license before you can braid hair, if that has, I think it would depend on what evidence was shown at the hearing for this. Because if it is targeting differently than, let's say, white hairstylists, then it's going to 100% be rational basis. If it's something that like everybody has this requirement, but maybe hair braiding is a slightly different or easier thing, maybe there's a requirement to be a barber, there's a requirement to be like a stylist, and there's a requirement to braid hair, and we're just testing the different technique, maybe it's going to be rational basis. But I don't know for sure because I don't have all the facts. But I think that that's a really good insight that it is probably strict scrutiny without knowing more. All right, 4, a public university creates a scholarship limited to one racial group.
Does it specify which racial group?
Nope.
Was the racial group a minority?
Does not say. Have I told you guys that in law school the answer is always it depends?
Yeah, that would make more sense.
What did you say?
Say, yeah, that sounds about right.
Yeah. It could go either way. And I will tell you the answer from a few years ago, and I'll tell you the answer now. A few years ago, we would probably say rational basis. If the rational basis behind this was to encourage more participation from minority groups, the government would say, that's totally cool. This is a concept known as affirmative action. There's a decision lately, though, that basically says that affirmative action is discrimination. And so we might have to apply strict scrutiny to this. And so, like, can Lincoln University, a historically black college or university, have a scholarship specifically for black people? It's a great question. Go ahead.
I don't know. I mean, depending on like if you're part of a sorority or something like that, I don't know if that's a.
Well, let's say that if the sorority has the requirement that you are a certain race. And then the question becomes, all right, is the sorority administering the scholarship, or is Lincoln University the state actor in providing the scholarship? These get really complicated really fast. And I don't want them to have to be for you guys. This is a great example of how it gets pretty murky because, 1, the law evolves, and 2, right now affirmative action is on the outs. It'll most likely come back at some point because it makes sense to give people equal opportunities for success. Right now, this will probably be strict scrutiny rather than rational basis, probably. And so what I want you to focus on here is the trigger. So is this state action, and what is the trigger? If the trigger is race, it is probably going to be strict scrutiny. All right, 5, a state gives extra points for veterans in public hiring. We did this example a little bit ago.
Points?
Yep, let's say that we have a competitive hiring thing, and we are going to score people So if you have like a bachelor's degree, you get 5 points. If you have a master's degree, you get 10 points. If you have a doctorate degree, you get 3 points. I'm kidding. You know what they say that a BS stands for bowl. You know what? An MS is more of the same, and PhD is pilot higher and deeper. That's my dad's joke because he has a PhD. The fact of the matter is, though, that a lot of people will have hiring practices based on a point system. So your degree gets you so many points. Your performance at the interview is out of 100, and you get scores from everybody. And in this, let's say that if you're a veteran, you get 10 extra points. Is that going? What level of scrutiny are we going to employ?
It depends.
What do you say?
Say rational, but say how.
Rational basis, most likely. All right. And then lastly, a city creates a curfew for people under 18. What's the trigger?
Age,
Yep. What's age usually?
bond.
Yep, rational basis. Okay. There are 3 types of discrimination, and I'm going to go through them really fast, but we'll pick up with that next class. There is facial discrimination. The law actually says only X can. Only men can do X, or only women can do Y, or only white people can go into this building. There's facially neutral discrimination, which is it doesn't mention a category, but it might still have the unequal effect. In order to be a firefighter, you have to be able to sustain a load of 80 pounds carrying it through a building, right? Tends to favor men over women. And then there's intent versus impact. Some equal protection claims turn on whether unequal outcomes reflect purposeful discrimination or not. I'm sorry, I said there's 3, there's 2 that I wanted to talk about. So with the firefighter example, what's the intent versus what's the outcome? Equal protection analysis often turns on whether government is classifying on its face or whether the dispute is about effect versus intent. And next class we're going to get into the toolkit for major civil rights and talk about the major civil rights stored in the U.S., race, legal changes, and enforcement. One thing that's fascinating about civil rights that I want to say right before we go is that this is fascinating to me because there have been lots of civil rights movements in our country. And I feel like it tends to follow a pattern because I think there's lots of evolutions of it. It usually starts with race, then gender, then disability, and sometimes then moves into like sexual orientation. But the fact of the matter is that the work that was done by people 2 generations ago has a very real impact on the privileges that we enjoy today. So next class, we'll kind of get into a little bit about that, and I look forward to seeing you all then. If you have any questions, I'll be happy to answer them, but I got to let some of the people go. And so if you need to get rolled, come get roll done, and then I'll answer questions too.